Massive 6-3 Supreme Court victory just dropped, and over 600,000 Americans are about to feel the impact. Justice Amy Coney Barrett led the conservative majority in a ruling that just demolished how federal judges have been blocking presidential power for years. 3 district court judges issued nationwide injunctions, trying to stop President Trump's executive order on birthright citizenship. But the Supreme Court said those judges massively overstepped their authority. Here's what makes this absolutely explosive. For decades, a single judge sitting in Seattle or San Francisco could halt federal policy for all 330 million Americans with one court order. The Supreme Court just said, enough is enough, and activist judges are panicking right now. We're breaking down exactly what happened, which judges just lost their power to block presidents, and why this could be the biggest shift in executive authority in 50 years. The real story. Nobody's telling the Supreme Court just rewrote the rules for over 600,000 future Americans. But the real story goes way deeper. The justices voted 6-3, and what they actually decided will shock you because it's not what the media is reporting. Roughly 250,000 babies are born every year to parents without citizenship or permanent residency. Over 3 years of legal battles, that's 750,000 children caught in a constitutional war. But here's the bombshell nobody expected. This case wasn't about citizenship at all. The Supreme Court looked at how much power federal judges should have and dropped a constitutional nuke. They ruled that district judges have been abusing nationwide injunctions for years, blocking presidential actions everywhere across America based on lawsuits from just a handful of people. These injunctions barely existed before the 1990s, but they've exploded into the ultimate political weapon. One judge can override election results affecting 75 million voters. The government's argument was brutal in its simplicity. If unelected judges can veto the elected president for everyone, we've abandoned constitutional government. 6 justices agreed, and the legal world is in chaos. The judges who overstepped Judge John Coffenor in Seattle became the face of judicial resistance to presidential authority. Appointed by Clinton in 1981, he's built a 4-decade career challenging executive power from the bench. When Trump issued his birthright citizenship order, Coffenor called it blatantly unconstitutional and did something extraordinary. He didn't just rule for the plaintiffs in his courtroom. He issued a nationwide injunction blocking the order in all 50 states for everyone. His Seattle courthouse has become the preferred destination for activist groups because they know his track record. But the problem got worse. Judge Lydia Grigsby in Maryland issued her own nationwide injunction in a completely separate case. Judge Angel Kelly in Massachusetts did the same thing in yet another lawsuit. 3 judges in 3 different states all blocked the same presidential order nationwide. This created legal chaos. The 9th Circuit backed Coffenor. The 4th Circuit supported Grigsby. The 1st Circuit upheld Kelly. 3 separate appellate courts all agreed these nationwide injunctions were proper, which forced the Supreme Court to intervene. Legal experts started asking a dangerous question. If 3 judges can each issue nationwide orders, and those orders conflict, which one controls? The system was breaking down in real time. The liberal justices fought back. Justices Sotomayor, Kagan, and Jackson dissented, with Sotomayor writing 44 pages that sound more like a warning than a legal opinion. She argued that fundamental constitutional rights require courts to have nationwide injunction power, warning about babies born without citizenship and the collapse of 150 years of precedent. Her logic says when rights are threatened, courts must protect everyone, not just people who hire lawyers and file lawsuits. The emotional appeal is powerful, but the reasoning creates a nightmare scenario. Under her standard, any of America's 94 district judges could declare any presidential action unconstitutional and block it nationwide immediately. One judge's interpretation becomes law for 330 million people. That's not checks and balances. That's judicial supremacy. Sotomayor also claimed limiting injunctions to actual plaintiffs creates unequal justice, where some Americans get protection while others don't. Justice Barrett destroyed this argument methodically. The Constitution already provides mechanisms for nationwide relief through proper class action lawsuits with certification requirements, or through appeals that reach the Supreme Court, where binding nationwide precedent can be established. Those processes exist for a reason. Individual district judges weren't meant to govern national policy from their benches. The shadow system exposed. Here's the number that changes everything: 300. That's how many nationwide injunctions federal district judges issued in just the past 8 years. A single judge can override presidential decisions affecting every American, and it's happened 300 times. This ruling sends shockwaves through every federal courthouse. The message is clear. Judges cannot substitute their political views for executive authority on national questions. The Constitution's design is straightforward. Congress legislates. Presidents execute. Courts resolve disputes and interpret law. Nothing grants district judges power to manage national policy because they disagree with presidential decisions. But activist organizations figured out how to game the system through forum shopping. They don't file lawsuits randomly. They research which judges issue nationwide injunctions against policies they oppose, then carefully file in those specific districts. Once they get their nationwide injunction, it applies everywhere immediately. The government must appeal, which takes months or years while the injunction remains active. By the time the Supreme Court reviews it, advocates claim the policy has been blocked so long that implementing it now would cause disruption. Temporary injunctions become permanent through strategic delay. This happened under Obama. It happened under Trump's first term. It happened under Biden. It's happening now. The Supreme Court just said this cycle ends today. The numbers reveal the stakes. The media fixates on birthright citizenship while missing the constitutional revolution. Migration Policy Institute data shows 250,000 annual births to unauthorized immigrants or visa holders. 3 years of litigation means 750,000 children affected. But look deeper. Foreign students on F-1 visas have babies while earning degrees. H-1B workers at tech companies start families. Tourists sometimes give birth during U.S. visits. The total impact spans millions of Americans. The real significance isn't about immigration. The Supreme Court established precedent affecting all nationwide injunctions across every policy area. Lower courts have blocked presidential actions on labor law, environmental policy, healthcare, immigration, and foreign affairs. Sotomayor's dissent warned this creates patchwork law where federal rules differ by location. 6 justices said the opposite is true. Nationwide injunctions from individual judges create chaos by encouraging forum shopping and litigation races, where whoever reaches a sympathetic judge first dictates national policy. The economic implications are staggering too. Businesses couldn't plan when any judge might freeze regulations nationwide. States couldn't coordinate when federal policies got blocked district by district. The old system created uncertainty that paralyzed governance. This ruling restores predictability by requiring relief to match the scope of actual harm proven by actual plaintiffs. Presidents just got more power. This decision hands enormous authority to every future president, regardless of party. The court didn't just rule for Trump. They created precedent governing all administrations for generations. Presidents can now implement executive actions without single district judges blocking them nationwide through preliminary injunctions. This fundamentally reshapes federal power dynamics. For decades, courts grew increasingly aggressive, declaring executive actions unconstitutional, then blocking them everywhere immediately. This ruling changes the equation completely. District judges must limit preliminary injunctions to actual parties before them, unless proper class certification or statutory authority exists. Future Democratic presidents implementing climate regulations face fewer obstacles from Republican-appointed judges issuing nationwide blocks. Future Republican presidents restricting immigration or regulations face higher barriers against progressive judges, stopping policies nationwide. Barrett's majority opinion rejected any inherent judicial power to issue universal injunctions. Proper preliminary relief protects specific proven harm to specific plaintiffs, not nationwide policy management. No exceptions. The current administration is already moving on executive actions they would have delayed before, knowing the nationwide injunction strategy just died. The next president, whoever they are, inherits this expanded authority. That's the real story. The presidency itself just became significantly more powerful relative to the federal judiciary. Conclusion. This Supreme Court ruling shifted the entire power balance between courts and presidents, and the effects are already visible. Trump's administration is implementing policies that would have been frozen months ago. District judges are rewriting how their orders work. Here's my question. Should one district judge block federal policies nationwide for all Americans? Or should their authority stay limited to parties in their courtroom? Drop your answer in the comments. If you want to stay ahead on Supreme Court decisions reshaping American power, smash that subscribe button and hit notifications to catch the next breakdown the moment it drops.